Good afternoon, and welcome to this edition of Disability Chat with Allison Bartlett. Today, we'll be talking about the 6 most common disability red flags. At the end of this session, Allison will answer your questions. You can send a question at any time during the presentation. Just click on the chat function in the toolbar, type your question, and hit send. Your questions can't be seen by others, only by HDSA. This presentation will be available in about a week on HDSA's YouTube channel, or by going to hdsa.org/disabilitychat. Be sure to join us for HDSA's virtual convention that will kick off on Thursday, June 4th at 4:30 p.m. Eastern Standard Time. You can join us by visiting the HDSA website, hdsa.org, and clicking on the convention landing page. Be sure to download the HDSA convention app, which will give you access to speaker bios, workshop evaluations, the workshop sessions each day, and the links to join each session. Please note that some sessions will require pre-registration, like our science sessions and support groups. So if you're interested in joining any of those sessions, be sure to pre-register where noted. Allison will be presenting a workshop with Jonathan Macedo on Friday, June 5th at 4 p.m. Eastern Standard Time on disability, when and what to disclose to your employer, and what to do when you can no longer work. You'll be able to send Allison questions during this session as well. On July 16th, we'll chat about completing disability forms, an overview of what Social Security disability forms you may receive during the disability application process and how to complete them. Allison Bartlett is HDSA's Manager of Disability Programs and is a disability attorney who specializes in representing clients with rare chronic conditions like Huntington's disease to navigate through the complex disability system. Allison holds a JD from the University of Cincinnati College of Law and a BA in International Affairs from James Madison University. And now I'll turn our chat over to Allison.
Thank you, Deb, and good afternoon to everyone on the webinar today. Thank you very much for joining me. So as Deb said, I'll be talking about disability red flags today. So I'm going to talk to you about 2 different kinds of red flags: Social Security specific red flags that are defined by Social Security rules and regulations and are written into the federal code. And I'm also going to talk to you about general red flags that can negatively impact your application. Red flag is a common description for a warning sign or an indication that something is not right. So what is a specific disability red flag? It is an indication that there is a problem with your disability application. Problems can range from completing the application incorrectly to violating federal law, which is a wide range of possible issues, but they all have consequences. So how will red flags impact your disability application? It increases the chance for a disability denial. Some red flags will result in an automatic denial, and it can also delay the processing of your case. Disability applications can already take months or years, so we do not want to create any additional cause for delay. Social Security has 7 defined red flags that are written into Social Security code that are grounds for denial. What this means is even if your claim meets the medical requirements for disability, so you meet listing 11.17 for Huntington's disease, you can still get denied for any of these red flags listed. Today I'm going to talk about these red flags in order from most common to least common. So one of the biggest issues for Social Security disability is earning too much income. And I know I have talked about this time and time again, but that's because it is one of the biggest issues for Social Security disability. So earning more than $1,260 per month gross is grounds for an automatic denial, even if you are found medically disabled. And the reason this is such an issue is Social Security has access to your IRS earnings record, so you are not able to hide this information from Social Security. If you have been working while your disability claim has been pending, Social Security will find your work information. It does work differently if you are getting paid under the table because that income is not reported, but it is still very much a risk. And with HD individuals, there is definitely a difference between someone who thinks they can work and someone who can actually work, which is why this is so important. There are a lot of individuals who lack awareness into the severity of their condition, so they think they really can go back to work full-time at a job they held previously and may continue to try to find jobs in the circumstance, but in a lot of cases they can't really work. And so what'll happen is they try time and time again to find a job. They may have a job for 6 weeks and they're making over this $1,260 per month amount, but they can't sustainably hold the job, which means they can't work, but it's also interfering with their ability to get Social Security disability. So who does this red flag impact most? It either impacts those who have a lack of awareness into their condition, or it impacts people who have been waiting years for a disability decision and have been forced to return to work in order to have any kind of monthly income. So how can this impact a disability claim? It can result in an automatic denial. It can result in reduced benefits. So there is something called a closed period of disability benefits. This is only something that's going to come up at a disability hearing because it's a very complex area of law. But what it means is you'll only get past benefits. You will not get benefits moving forward. Let's say you submitted a disability application in January of 2018. And you do not have a hearing until May of 2020. So that's 2.5 years almost that have passed. In June 2019, you had to go back to work because you had no other income. The judge decides that you were disabled in January of 2018, but you could no longer get disability benefits past the date you stopped working. So what that means is you'll get disability benefits from January 2018 through June 2019, but you won't get anything after that. What that also means is if you have to stop working at this job that you started in June 2019, you'll have to apply for disability benefits all over again. So it's something to consider. It could also reduce back pay based on the income you received while working. So you may still get benefits moving forward, but any of your possible back pay would be reduced. You could also have to argue unsuccessful work attempt. This is if you return to work above substantial gainful activity, $1,260 per month, but are not able to work for more than 6 months. So you have to keep track of all of that. Earning too much income could prolong the hearing process, and it could prolong the hearing process because it means your hearing decision could get pulled for review. Appeals counsel is not only another stage of the review process, they also review all hearing decisions that are made. So a judge could pull a decision, or the appeals counsel could pull a judge's decision, review it, ultimately decide the judge made an error, and have to send it back. This actually happened to one of my clients, and it delayed her case by almost 2 years. Her original hearing was in February of 2018. Her decision was finally processed in July of 2018, so that already took 6 months. The appeals counsel pulled the decision the day the decision was released. It took the appeals counsel a year to decide that they had to send the case back to the judge because the judge made a mistake. So it's July 2019. We have to go to another hearing, which isn't scheduled till December 2019. Ultimately, she was awarded reduced benefits, but she didn't even see those benefits until January of 2020. That is a huge risk. And earning too much income makes the whole claim more complicated because then you have to submit evidence to Social Security when you start working. If you ultimately stop working, you then have to submit evidence to Social Security when you stop working and why you stop working. If you decide to return to work while your disability claim is pending, you need to speak with me or you need to speak with your attorney if you have one. Attorneys are not able to fix if you work over the SGA amount after the fact, and we definitely cannot help you if you do not disclose to us that you are working. If your attorney asks for copies of your pay stubs, you need to submit all of them as soon as possible. If your attorney asks if you're working and how much you're making every month, you need to answer honestly. An attorney cannot adequately help you through the disability process if you lied to them. There are exceptions to the earning too much income. There are things an attorney can put in place to make sure you get benefits, but you have to be honest and you have to share that information so the person helping you with your case can take the appropriate next steps. The next red flag is drug or alcohol abuse. Your disability application will be denied if your disability is a direct result of drug or alcohol abuse. In the 1990s, drug and alcohol abuse were grounds for disability claims. You could be found disabled due to drug and alcohol abuse, but Social Security has drastically shifted this policy, and now it is a red flag. Many individuals with HD partake in drug or alcohol use. Individuals with HD who partake in drug and alcohol use often does not rise to the level of abuse, but you still need to be aware of all of these issues when submitting a disability claim. It is safer to treat most drug and alcohol use as abuse for the purpose of Social Security disability in order to be overly cautious and address Social Security concerns. Especially with HD, there are many reasons behind the drug and alcohol use. It could be a result of cognitive decline or reduced inhibitions, or it could be a form of self-medication. It helps to have an understanding or awareness of the reason for the drug or alcohol use, because that information is relevant and necessary to a disability application. Drug or alcohol abuse is often documented in medical evidence as well. In my professional experience, after reading thousands of pages of medical records, neurologists, especially HD specialized neurologists, will put in the medical records if someone is drinking, if someone is using drugs, and the potential consequences that could have on their HD and their HD diagnosis. And that is why it is so important to understand why someone is using drug or alcohol, because that can help mediate Social Security, like what that's going to have an impact on their HD claim. And because in a lot of cases, HD individuals do use drugs and alcohol to self-medicate because there is no cure at this time. And it's important to have an understanding and make Social Security understand why this is going on. And we'll get to why this is so important in the next slide. But as we all know, HD is not caused by drug or alcohol use. Symptoms could cause progression or worsening of the condition because of drugs or alcohol, but HD is caused by a gene and not drug or alcohol use. And this is also important, and I'll get to that in a little bit. So, if someone is using drugs or alcohol, if they're abusing it, you have to show that the drug and alcohol abuse is not a material factor in the disability claim, and you have to show that HD symptoms will persist regardless of the drug and alcohol use. So how do you do that? How does Social Security decide if drug and alcohol use is material to the disability claim? First, they look to see if drug and alcohol abuse is involved. Alcohol abuse includes drinking every day or drinking a substantial amount a few days per week. Drug abuse includes prescription and illegal drugs. If you are taking illegal drugs, assume Social Security is going to treat that as drug abuse. You also need to be aware that marijuana is still illegal at the federal level, and Social Security is a federal program. Even if medical marijuana is legal in your state, Social Security will likely do this analysis to determine if your medical marijuana use has any impact on your HD symptoms. You will need to speak with your doctor directly about any potential medical marijuana use with your doctor directly if you are using medical marijuana to treat your HD. Second, Social Security will look to see if the drug and alcohol abuse is the only impairment. This step is very important because HD symptoms and drug and alcohol abuse symptoms can be very similar, especially cognitive symptoms. And you're going to need clear evidence that your symptoms are caused by HD and not the drug and alcohol abuse. HD is one of the few conditions where you can apply for disability too soon, so you do have to be careful. What would be a clear case of drug and alcohol abuse not being material to a claim is if your HD symptoms start before the drug and alcohol abuse starts, and you have clear medical documentation that your HD symptoms were an issue before the drug and alcohol abuse started. Third, Social Security will look to see that the HD impairments, which include motor, behavioral, or cognitive symptoms, are disabling by themselves, or if they are disabling because of the drug and alcohol abuse. This can be difficult to distinguish in an HD case because the symptoms of HD and the symptoms of drug and alcohol abuse can be very similar. This highlights the importance of working closely with your neurologist to determine the appropriate time to apply for disability and making sure you have the necessary medical evidence. Fourth, Social Security will look to see if the drug or alcohol abuse caused the HD or if it impacts the HD. As we know, drug and alcohol abuse does not cause HD, but it can definitely impact HD by making symptoms more severe or creating additional symptoms, which can make it a lot harder for Social Security to find someone disabled if they cannot determine why someone cannot work anymore. Lastly, Social Security looks to see if the individual with HD would be disabled without the drug and alcohol abuse. Again, this is hard because eventually a person with HD will be disabled as the symptoms and the disease progress, but this is not clear-cut. Someone with prodromal HD or someone who is unsymptomatic will not be found disabled regardless of whether they have drug or alcohol abuse or not, because their HD is not yet disabling if they have no symptoms. But someone with mid-stage HD who has behavioral, cognitive, and motor symptoms along with drug and alcohol abuse would likely still be found disabled because their HD symptoms are not going away and they're not going to improve and they're disabling regardless of drug and alcohol use. I understand that this is very complex and would be very difficult to address in a disability application, especially without training. That is why it's important to have a neurologist, to be honest with a neurologist, and to speak to me when filing a disability claim. For families and individuals with HD, this is the most important question you have to answer. Will your HD symptoms improve without drug or alcohol abuse? In order to be found disabled, the answer has to be no. In some cases, you may have to determine if the symptoms are actual HD symptoms or if the symptoms are drug or alcohol abuse-related symptoms. If the neurologist is unsure and there is no clear difference between the HD symptoms and the drug and alcohol abuse symptoms, then it will likely not be the right time to apply for disability, and the drug and alcohol abuse will need to be controlled. The important thing here is to focus on the word symptoms because there is no cure for the HD gene at this time, and there's no cure for HD symptoms at this time, but having the gene does not automatically mean that you are experiencing symptoms. So again, when looking at a disability application, you have to focus on the existence of HD symptoms, not HD itself. Social Security does look to see if you have made a good faith effort to stop the drug and alcohol abuse. So have you entered into a treatment program? Have you cut back use or tried to stop on your own? Experiencing a drug or alcohol relapse will not destroy a disability case. And for many individuals, drug and alcohol abuse is secondary to other underlying conditions. That's important to know. Social Security cannot find you disabled if you are not getting treatment for the underlying conditions or the underlying conditions are not disabling themselves. So again, Social Security cannot find you disabled if you're not getting treatment for your condition, not as relevant for HD, but they also can't find you disabled if your underlying condition, your HD, is not yet disabling itself. So what if the drug and alcohol abuse caused the impairment? This question, again, is relevant to HD symptoms, but not the HD gene itself. With HD, it is all about the symptoms experienced and not the HD diagnosis itself, since individuals have the gene when they are born. So, no. If the drug and alcohol abuse caused the impairment, that fact alone will not preclude an individual from being found disabled. A really good example of this, not pertinent to HD necessarily, but a good example is pulmonary hypertension, because pulmonary hypertension can be caused directly from methamphetamine use. So it's a condition or impairment caused directly by drug abuse. But HD is an incurable disease once it's created and will remain even after the methamphetamine use stops. I also used to specialize in representing PH patients. I had a lot of PH patients who developed PH because they used methamphetamine in the past. But having pH negates all other drug use, because once you have pH, using meth isn't actually going to make the pH worse, and stopping the drug use isn't going to change the fact that they had pH. So that was a clear case where drug use was no longer material to the case. So with HD, HD cannot be caused by drug or alcohol use, but symptom onset could be earlier because of drug or alcohol abuse. The HD symptoms will likely remain even once the drug and alcohol abuse stops, but it doesn't change that the HD is still present. Again, the main focus here is not whether the drug and alcohol abuse created the impairment, but that the impairment remains when the drug and alcohol abuse is gone. So an important question is it harder for individuals with mental conditions to prove that drug and alcohol abuse is not material to their case? Unfortunately, the answer to this question is a resounding yes. It is harder for individuals with mental conditions to prove that drug and alcohol abuse is not material to their case, especially conditions that are psychiatric or emotional, like Huntington's disease. Most psychologists and psychiatrists believe that even moderate alcohol use contributes to depression. And this is relevant because almost all HD patients experience psychiatric symptoms like depression. So why is this harder to prove? In many cases, the symptoms of HD and drug and alcohol abuse are the same. They're memory loss, difficulty concentrating, irritability, etc. So if your neurologist cannot tell what is causing your symptoms, then Social Security will not know either. And Social Security is going to assume that your impairment is caused by the drug and alcohol abuse unless you can prove otherwise. So the next red flag that is really prevalent in HD cases is failure to cooperate. There is no excuse for failing to cooperate. But unfortunately, often the reason an HD claim is denied for failure to cooperate is because the individual with HD applied without assistance. They forgot about the claim. They didn't realize they applied for disability, or they were not able to finish the application due to cognitive difficulties. I cannot stress enough, and I think I stress this in every webinar, that an individual with HD is not the only person that needs to be responsible for a disability claim. It needs to be a group effort, and they need to have assistance. So what does it mean to fail to cooperate? It means that you're failing to adhere to Social Security's rules, requests, and guidelines in a timely fashion, or failing to reply at all. So how does this impact a case? It often results in a denial and will likely result in multiple denials. So if you do not comply with information requests at the initial application level and you do not correct this issue on appeal, your appeal is also going to get denied. So your case is going to continue to get denied until these issues get fixed. And if you're someone with Huntington's disease and you're not getting help with a disability application, it can be really hard to fix these issues because you likely aren't aware that they're happening. This can also cause a lot of delay in processing your case because Social Security will have to wait longer to move forward with your case, and they'll have to spend more time following up with you, which just makes everything take that much longer. So what are some examples of failing to cooperate? You do not submit both halves of the disability application. So a lot of people don't know this, but the application actually comes in two parts: the application for disability insurance benefits and the adult disability report. If you do an online application, they make you submit the application for disability insurance benefits before you even get to the adult disability report. The adult disability report is where you put in your doctor's information, what conditions you've been diagnosed with. So the application for disability insurance benefits, there's like no place to put in there that you have Huntington's disease unless you use the remarks section, which please use the remarks section. But a lot of times what I saw is people would submit the application for disability insurance benefits. So Social Security would receive that application, but people would never finish the adult disability report. Since that's where you say what conditions you have, who your doctors are, what your past work was, that's like where the really important information for your case is. Social Security can't actually make a determination if you're disabled if you don't submit that part of the application. Another example is you do not complete all of the forms that Social Security sends to gather additional information about your claim. Social Security is not going to send you forms for no reason. If they're sending you something, it's because it's important to your claim and you need to complete that information. So that includes things like work activity forms or an adult function report. This is all really important information to your claim. You refuse to release medical records to Social Security. If you refuse to release medical records to Social Security, why did you apply for disability in the first place? As I've said over and over again, if you have no medical evidence, Social Security cannot approve you for disability because then there's no documented proof that your disability exists. And a big one that comes up a lot, if you do not attend the Social Security medical exam, or the consultative exam as it's called, if one has been scheduled, you're going to get denied. Consultative exams are paid for by American tax dollars. Social Security takes these exams very seriously. They're not going to schedule you to go to a consultative exam if you don't need one. And and one thing that is important to know, you are able to change the date and time of the medical exam if you have a conflict. So if you have a conflict, it's essential that you talk to your claim examiner as soon as possible so they can get the appointment rescheduled so you can actually go. The next red flag is not following prescribed treatment. At this time, there is no HD treatment that will restore an HD patient's ability to work, but it is important to be aware of this red flag because HD is often accompanied by other behavioral diagnoses, and there have been a lot of advancements and developments in HD treatments in recent years, so it might not be too far off when this does become relevant. So not following prescribed treatment means failing to follow your physician's prescribed treatment that would restore your ability to perform full-time work, and this would result in a denial. So what they mean by physician is a treatment must be prescribed by your treating physician, not a consulting examiner or a Social Security physician. So in this case, your HD specialized neurologist would have to prescribe treatment that could restore your ability to work. And you don't follow it. And what is considered treatment? Treatment includes medication, physical or occupational therapy, or surgery. There are exceptions to this rule. So there are medical exceptions. You have a severe mental illness and are unable to follow prescribed treatment as a result of your condition. This needs to be documented by your mental health provider. This is a really important one to know because a common symptom of HD is a lack of awareness of HD, which falls into this category. A lot of individuals with symptomatic HD don't realize they have symptomatic HD, so they wouldn't be able to follow prescribed treatment. So it's important to recognize this exception. Another exception is you have an extreme fear of surgery that is well documented by medical records and your mental health provider. Or the prescribed treatment is unusually risky surgery like open heart surgery, organ transplants, or it's an experimental procedure. This is another key trigger, because pretty much everything with HD treatment right now is an experimental procedure. And lastly, prescribed treatment involves amputation of an extremity. So you don't have to follow prescribed treatment if it means you have to lose a limb. There are also non-medical exceptions. This includes prescribed medical treatment violates your religious beliefs. You must state your religious affiliation and you have to provide evidence that you are a member of that church. Or treatment prescribed by your treating physician conflicts with the advice of another treating source. This also needs to be documented by medical evidence. So this is perhaps you have two neurologists and they don't agree on how to treat you. Then you don't necessarily have to follow the prescribed treatment of one if it conflicts with the prescribed treatment of the other. And last, and this is a big one, you cannot afford the prescribed treatment or medication. So you have to show that there are no free or low-cost clinics in your area, and you have to show that you've exhausted all options. To show this, it would be really helpful, like if you got a letter from your neurologist stating that you've gone through, like, if your clinic doesn't offer any low-cost options, if there's nothing around, like you do have to put in, you have to show that you've exhausted your options, but there are ways to do that. The next red flag is Social Security is unable to locate the claimant. Honestly, this is something that shouldn't come up. Yes, there are definitely extenuating circumstances. There are people who experience homelessness, so there are situations where this could happen, but in most cases, there's not a good reason for this ever to happen. So if Social Security is not able to find or communicate with you, they will not give you benefits, which is 100% fair. Would you send someone a check if you don't actually know where they live? So reasons Social Security may not be able to find you: if you do not confirm your mailing address, if you do not provide the correct phone number, if you do not answer the phone, or if you do not maintain any kind of contact with Social Security. These are things that are easy to get around. If you know you're never going to answer the phone, don't give your phone number. Give your spouse's phone number. Give your friend's phone number. Give Social Security the phone number of somebody who will answer the phone. Like, if you are not able to check your mail, don't provide your mailing address. Give somebody else's to make sure things get looked at and are received. I did actually have a client once where we spent months gathering all of her medical evidence, preparing her claim, submitting her claim, only to find out that she had been approved like a year previously, but she had failed to confirm her address with Social Security, so they never paid her benefits. And I spent 6 months of my life working on something that didn't need to get worked on. And this is an example of why HD disability claims need oversight from someone who does not need HD. I was extremely frustrated by this because I spent a lot of time I didn't need to, but the client went at least a year without getting benefits that she had already been approved for because she didn't confirm her address. Please don't be that person. The next red flag is being convicted of a crime. So imprisonment, so if you're in federal prison, will prevent you from receiving Social Security benefits if you have been convicted of a felony and are currently in prison. You could technically still be approved for disability benefits, but you will not receive any benefits while you are in prison, and that's because federal tax dollars are supporting you while you're in prison, so you can't double dip, as they say, and since you're in prison, you are being punished for a crime you committed, so you also can't receive benefits. The other way is criminal convictions can prevent you from receiving benefits in certain circumstances. If you were injured while committing a felony, the injury cannot be used as the basis for Social Security disability. So let's say you lose your leg in the process of committing a felony, you can't apply for disability because you lost your leg. The other thing is, if you're injured while in prison, the injury or the worsening of the injury from prison cannot be used as the basis for Social Security disability. This isn't going to be relevant for HD specifically, but if you have HD and another diagnosis, and the other diagnosis or condition and limitation resulted because you committed a felony, you couldn't get disability for that other injury. You also can't get disability for your HD while you're in prison because you're in prison. And this is something that is relevant because, unfortunately, people with HD can be disproportionately penalized for crimes because of all the things that go along with having HD, because of the cognitive decline, because of the lack of inhibitions. There are people with HD who end up in prison for things they commit as a result of their HD, and so they can't get benefits while they're in prison, but they could get benefits when they get out of prison. And the last Social Security red flag is committing fraud. So if you obtain disability benefits by dishonest means, Social Security can and will terminate your benefits. So this includes making false statements and providing untrue information, like stating you have no source of income, but in fact you do, or hiding facts or evidence that affect eligibility for benefits, like not disclosing that you are in prison, or not disclosing workers' compensation. You have to legally disclose if you're receiving workers' compensation, because your disability benefit amount will be reduced if you receive workers' compensation benefits. And the reason for that is these are both federal benefit programs. So they're coming out of a similar fund. So it does impact how much you'll receive. Also, if you obtain benefits through fraud on the part of someone working for Social Security, your benefits can also be terminated. Like if you bribe a Social Security employee, don't do that. And this is not ever a risk. Do not ever hide information from Social Security because you think it will hurt your claim. It's not worth the risk. So what will happen if you commit fraud to obtain your disability benefits, eventually Social Security is going to find out, and when they find out, they'll make you pay back everything they wrongfully paid you. So you could end up owing the federal government $30,000, $50,000. You don't want to be in that position, especially if you really justifiably need the disability. It's not worth the risk. Now that I have discussed Social Security red flags, I'm going to talk about general red flags. In my professional experience, these are the red flags that have created a lot of issues for individuals and families. So failure to get medical care on a regular and consistent basis will have negative consequences for your disability claim. It definitely increases the chance for a denial. It limits the available medical evidence in your claim. For example, if you have a neurology appointment every 2 years versus having a neurology appointment every 6 months. The person who goes to the neurologist every 6 months will have 4 appointments in 2 years instead of 1. A lot of HD changes can happen in 2 years, and 4 appointments could mean 4 times the amount of available evidence in a disability claim, especially if your doctor takes very thorough notes and documents every change at every appointment. This also prevents Social Security from gathering accurate information about your HD, because if there's not medical evidence, the information is just not there. And will delay the processing of your case because Social Security has to have medical evidence from an appointment within 3 months of the date you submitted your application. If you haven't gone to the doctor in a year when you submit a disability claim, this means you're going to have a consultative exam scheduled with a physician, which delays your case, but it also means that you're likely going to have to see a physician that probably doesn't know much about HD and is not going to do your disability claim as much justice as seeing a specialized neurologist who knows you, who knows your HD, and who understands how it's impacting you. Failing to get regular medical care also means you're not going to have the same amount of changes documented in your case. Regular and consistent medical care will highlight changes in your HD. You cannot show progression of your HD symptoms if you do not go to the doctor. And Social Security will not know what HD symptoms you experience if they are not documented in your medical records. So medical care equals medical evidence of HD symptoms and limitations. The more medical documentation that you can provide about your symptoms and limitations, the stronger your case will be. The more medical providers you see will also provide a more in-depth look at your HD symptoms and limitations. And for example, one gene test appointment 1.5 years ago is not enough evidence of your HD to be found disabled. For example, we have 2 HD patients with the same symptoms: issues with tripping and dropping objects, memory loss, difficulty completing tasks and concentrating, and worsening irritability. One patient, Bob, sees his neurologist once per year and does not get any other care. The other patient, Ed, goes to the neurologist every 6 months, sees a psychiatrist, and attends physical therapy. Who is going to have more evidence to submit with their disability claim? Ed is not only going to have more evidence in total, he is likely going to have more substantial, detailed evidence since he is getting treatment from multiple physicians that can evaluate all aspects of his HD, which his motor, his cognitive, and his behavioral symptoms. Another big red flag is not being honest about your symptoms and limitations. So disability application is about what you cannot do, and I know I have said this many times before. Only talking about what you can do will send Social Security the wrong message because it will indicate that you can work and you are not disabled, which is often not actually the case. Most people that I talk to, most people with HD can no longer work because their HD now prevents them from working. And so that is the message that you have to send. You can include what you can do in your application as long as you include your limitations and any accommodations that you have made for yourself. For example, I can load the dishwasher, but I cannot wash the dishes by hand anymore because I dropped them. Or I can put clothes in the washing machine, but I cannot remember to move them to the dryer, so my wife does it for me every time. If you are unable to work because of your HD symptoms and limitations, you are not fine. So you should not tell people you're fine. You especially should not tell your doctor you are fine. Do not dismiss your symptoms when talking to your doctor. Social Security reads what your doctor writes, and if your doctor writes you are fine, then Social Security will think you are fine. One thing that happens a lot is a doctor will ask you, how are you doing today? And the common answer is fine. It's like the question and response thing that we've become accustomed to in our society. That is never the right answer when you're talking to your doctor and you need to apply for a disability. You can't say fine. You have to say, I've had a lot more bad days in the past few months. My symptoms have gotten worse. These are things that I'm dealing with now. I know I fall victim to this too. Like, I do it too. When my doctor asks me how am I always say fine. And if you know that's a risk that that's going to happen, make sure you have notes prepared before you go. Start keeping a journal. Make sure you're prepared to answer the question before the question happens, so you make sure the most evidence is in your medical records. And if you have trouble talking to your doctor about your symptoms, then have a friend or family member join you at your appointments. This is also beneficial because friends or family members can also recognize symptoms that you may not see because you live with your HD every day. So I've created a way to highlight how not being honest about symptoms and limitations can appear to Social Security and why it'll hurt your claim. Ed and Bob have the same symptoms and they have undergone the same neurological testing, which has displayed similar results, indicating that there's a good chance neither of these men are able to work. They've both applied for disability, and this is the last step in the process for Social Security to look at their activities of daily living. So these are the answers that Ed and Bob have put on their adult function report that Social Security sent them. Based on these answers, who appears disabled? If Social Security can only find one of them disabled, that's not actually how it works, but for sake of this hypothesis, Social Security can only find one of these gentlemen disabled. Who appears disabled? The answer is clearly Ed. Has Bob given us enough information to really understand his HD or his limitations? No. Would you feel confident in your disability application if you answered all of the questions like Bob? I really hope your answer is no. And this is why you have to provide as much detail as possible. And it can be little things that you put in your application as to the changes that you've made, but little things can make a really big difference. Which is why my next webinar is going to be how you actually fill out forms. But getting back to the red flags today, one big thing that leads to HD individuals not being honest about symptoms and limitations in their applications is anosognosia is a common HD symptom. Anosognosia means lack of insight, and it means an anosognosia impairs a person's ability to understand and perceive his or her illness, and is why people with certain conditions like HD, bipolar disorder, and schizophrenia refuse medications or do not seek treatment. They honestly don't think they need it. So how do you help someone with anosognosia or a lack of insight into their HD? Well, one big thing is you need to communicate this lack of awareness and insight with their neurologist. You need to share this symptom with the neurologist so the neurologist knows, and so you know how to help this person. You can help them complete their disability application and all Social Security forms, so the forms accurately reflect the person's symptoms and limitations. I stress that if someone does not have good awareness into their symptoms and limitations, they should not be the one submitting the disability application on their behalf, because they're not going to answer the questions honestly and they're not going to do the application justice. And if you don't feel comfortable submitting the application for them, or if you don't feel comfortable going, it's not behind their back, but answering questions truthfully when they're not able to, then get help from an attorney or a social worker or someone else. I have told many families in the past that it is okay if the HD patient doesn't like me, their attorney, because I don't do this to make friends. I'm doing this to make sure people with HD get the benefits they need and deserve. Attorneys can say things that family members can't, because attorneys have to be honest and accurate, and a family member sometimes is in a situation where they can't do that. It is important to stress that if a family hires a disability attorney, they need to be no, they probably don't need to be president, but they need to be present, and they need to actively communicate with the attorney, because the individual with HD is not able to advocate for him or herself. They're not capable of telling the truth. It's like, do you expect someone who has had to have their hand amputated to be able to use that hand anymore? No. So do you expect someone with HD to be able to fully use their cognitive faculties? The answer is no. Like, my job, an attorney's job, like who helps with disability, our role is to be blunt. It's not to be mean, but it's to be blunt and upfront, and to let you know what you need to do to make sure a disability application goes through. We understand that not everyone in this direct circumstance, not everyone applying for disability can do that, and that's okay. But that's why you need to ask for help. That's why family members and friends even need to be actively involved in this process. It is not something that can be done alone a lot of the time. And lastly, good faith effort. Not caring about the quality of the information included in the application could lead to a denial. In my experience, individuals who do not really care about their disability application are at risk for failing to cooperate with Social Security, which, as we discussed, is a Social Security red flag. So it increases the likelihood of a denial. And not putting in good faith effort means a lot of different things. It means an inaccurate or an incomplete application is submitted. Often it means that the application lacks necessary detail, so it doesn't include all medical providers, or does not include all the necessary medications. The application does not include all the jobs the person had in the last 15 years, or the job descriptions provided are not accurate. And it also means a lot of times that forms are not completed or returned in a timely fashion, if they're completed at all. So the question here is, if you do not care about your disability application, why should Social Security? The person who is responsible for their disability case and for submitting the disability application is the person who submits the application. No one else can care for you. No one else is really responsible for the application. It's the person who submits it. And I know if you're lucky, you'll find a really good attorney who does care enough for you, who will help you fight through this process. It's hard to find an attorney like that. I know I was one of those attorneys. There were times that I had to make my clients care when they didn't, but that often is not what's going to be what happens, because most attorneys have a really large caseload. And if you don't care about your case, if you don't care about your own case, then your attorney is not going to care as much about the case, and it is going to get pushed to the wayside. It's going to get pushed to the bottom of the pile. It's a harsh reality, but it is the reality. If you don't care about your case, no one else is going to care. But here, what's important to recognize, if you don't care about your case because you don't care, or if you don't care about your case because it's a symptom of your HD. And that's why it's so important to get assistance, because it's a symptom of HD. It's something that happens with disability cases, but it's important to recognize, because if you don't care about your case, you need to have someone in your life that's going to help you care about your case to make sure everything gets done. So are there any questions?
So Allison, we actually do have a question here. You gave us an awful lot of great information today, and we went into depth on a lot of different areas and red flags. Where on the HDSA website can we find some of the information that you talked about today?
So you can find a lot of this information on the disability page of the HDSA website. There's different resources and it can access me, but a lot of this stuff is either on Social Security's website or it's stuff that I learned from doing this in practice. So it's the kind of thing that it's really good to ask me questions about. It's a good thing to talk to your social workers about, but a lot of this information is on the disability page of the website. It's just located in different forms within the resources that I've created and the way I communicate with individuals. It's just good. It's something that should become general knowledge, which is why I give these presentations.
Okay, well, looks like you've covered everything and we have no further questions for today. So I want to thank you very much. Remind folks that we'll be coming back on July 16th to talk about completing disability forms. And also, please be sure that you do register for the convention. Allison's workshop will be on Friday, June the 5th at 4 o'clock Eastern Standard Time. She'll be joined by Jonathan Macedo, and they will be talking about when to disclose and what to disclose to your employer, which is a really important topic to so many of our family members. So thank you, Allison, for your presentation today, and we look forward to having all of you join us for HDSA's convention in June.